This lot is the second part of our selection of cases from 2010. I've tried to select cases which are either significant legally or which could impact on how you deal with employee issues at your organisation. The first case is Tullett, Prebon and BGC. It's the highly publicised team move case, which illustrates the risks that can be involved in orchestrated poaching raid. Tullett and BGC are two of the major interdealer brokers. Tony Verrier, the former Chief Operating Officer of Tullett, became Managing Director of BGC and began a recruitment campaign among his former colleagues at Tullett. His intention was to recruit entire teams or desks, and in order to do that he used the desk heads as recruiting sergeants. So as a result, 13 brokers signed contracts to join BGC when their Tullett contracts allowed, although 3 actually later changed their mind. BGC offered a signing-on payment and provided the employees with full indemnities covering any liability from them leaving Tullett. In fact, the brokers resigned from Tullett without notice, claiming that they had been constructively dismissed. Tullett brought proceedings against BGC, its president, Sean Lynn, Mr Verrier and the individual brokers, alleging inducement to breach of contract, conspiracy and misuse of confidential information. The brokers' employment contracts contained an express clause requiring them to disclose to Tullett any direct or indirect solicitation by a competitor. Interestingly, the High Court held that such a duty to confess was enforceable and was not an unlawful restraint of trade. Moreover, the desk heads, as senior managers, had extra fiduciary obligations requiring them to disclose that a rival was trying to recruit the desk. So that obviously meant then the desk heads could not do anything to assist in that recruitment. This applied to providing information, even if the information was not confidential. The judge said it may be a breach of an employee's duty to provide any information, confidential or not, to a rival of his employer if he knows that the information is to be used to assist the rival and to harm his employer. The judge found that the employees who resigned had not been constructively dismissed by being asked to attend meetings where they were warned that if they left early, then legal action would be taken against them to enforce their contracts. The judge took the view that Tullett's conduct was not intended to attack the relationship between it and the brokers, but was intended to strengthen it. BGC, Mr Lynn and Mr Verrier were also found liable for inducing breach of the brokers' contracts with Tullett and for conspiracy to induce those breaches. The judge concluded that their exit plan was for the brokers to leave whether or not they had good grounds for claiming constructive dismissal. The judge also held that contractual provisions which required repayment of signing or loyalty payments if the employee did not serve out the full term were not in restraint of trade and so could be enforced. Finally, the court granted injunctions to enforce garden leave and post-termination covenants against the brokers for a total period of 12 months. The judge held that, unlike a covenant, the enforceability of garden leave is to be considered at the time of enforcement, not at the time of contracting. This is a complex case and it deals with a raft of complex issues. In the limited time available, I think the key lessons to draw from it are: first, an obligation to disclose solicitation to your employer is enforceable. Providing information to a rival may be a breach of contract, even if the information is not confidential. It is possible to enforce a garden leave clause for 12 months, which have been debated before. And if you want to poach a team of employees from a rival, then you need to tread extremely carefully. Moving next to the case of Kraft Foods and Hasty, which concerned a generous redundancy policy subject to a cap. The cap ensured that a redundant employee did not receive more than he or she would have earned if they'd remained in employment until retirement age. The cap was challenged by older workers as being discriminatory on the grounds of age. There are 2 key questions relevant to any age discrimination case. First of all, is there discrimination on the grounds of age? And secondly, if there is this justifiable? The imposition of a cap does bite more on older employees than younger ones, so it is, on the face of it, discriminatory. However, the more involved issue is that of justification. if the discriminatory practice constitutes a proportionate means of achieving a legitimate aim, then it can be justified. Proportionate means, for example, that what the employer is doing is actually achieving its aim, or that the discriminatory effect should be significantly outweighed by the importance and benefits of the aim. And legitimate means, for example, economic factors such as the needs and efficiency of running a business, or the health, welfare and safety of an individual. The main consideration in this case was whether the employer's aim was legitimate. Was it simply to save costs, or was it to prevent an employee receiving a windfall? A previous case had decided that an employer seeking to justify a discriminatory practice cannot rely solely on considerations of cost. This case concerned a cap on the amount payable under a redundancy policy to prevent employees being better off as a result of receiving that redundancy money than if they had worked until retirement. In those circumstances, the EAT found it is legitimate for a redundancy scheme to incorporate a provision designed to prevent excess compensation, and so the cap was a proportionate means of achieving a legitimate aim. So if you do offer a generous redundancy policy which is subject to a maximum cap, this case gives reassurance that that cap will not fall foul of the age regulations. I'll just mention the case of Woodcock and Cumbria Primary Care Trust, which also turned on the issue of justification, and it was heard by the EAT earlier in the year, and the judgment was handed down a few weeks ago. And in this case, the EAT upheld the tribunal's decision that the age discrimination in that case was justified, where the employer's main aim was to save costs by depriving Mr. Woodcock of a generous pension windfall. The EAT also expressed support for the argument that the sole aim of saving costs should, in certain circumstances, be sufficient justification for discrimination. So this is a potentially helpful development in terms of making it easier for employers to justify age discrimination. The next case is South Yorkshire Police and Jellick, relating to disability discrimination, and it contains a warning really to employers as to the scope of the duty to make reasonable adjustments. The case concerned a police officer who developed chronic anxiety and was found to be no longer fit to carry out frontline duties. He was assigned a desk job, but then, due to a reorganisation, it was decided that he would be medically retired. The EAT upheld a finding of the tribunal that it would have been a reasonable adjustment for the police instead to have deployed Mr. Jellick into a job which did not involve facing the public, and they could have done this by swapping his frontline post with the post of another police officer. The EAT rejected an argument that the most an employer has to do in this context is to transfer the disabled employee to an existing vacancy. The judge emphasised that all adjustment cases are highly fact sensitive, but the tribunal said that because the police are a disciplined service, the other police officer could be ordered to move whether he liked it or not. So the message here is that tribunals are taking an ever wider view of what constitutes a reasonable adjustment, and whilst the case ought to be limited to employers like the police who operate on a command basis, it is a reminder of the need to go further than you might first think necessary in order to satisfy the duty to make reasonable adjustments. The next case is Khan and Martin McColl, which relates to the vexed issue of holiday pay during sick leave. The decision was, I think, rather harsh for Mr. Khan, but very good news for his employer. Some of you might remember the case of Stringer and HMRC, which we covered in a similar slot at last year's seminar. And in that case, the European Court of Justice held that workers who were on sick leave continue to accrue holiday rights. And if they're prevented from taking their holiday due to sickness, they have to be allowed to carry forward that holiday to the next leave year. And if the holiday has not been taken by the time their employment terminates, then they have to receive payment for the accrued but untaken holiday. In Mr. Khan's case, he had carried forward 2 weeks holiday from 07 to 08. He had an entitlement of 4 weeks holiday for 08. He did not take any holiday and went off sick in May 08 until he resigned in August 09. The employer paid him for 2 weeks accrued but untaken holiday for his 09 entitlement. Mr. Khan brought claims for 6 weeks holiday pay for the holiday accrued during 07 and 08. His claim for unlawful deduction from wages was held to be out of time because the payment by the employer of his 09 holiday had broken the series of deductions. And as regards his argument based on the Stringer case, the tribunal found that since he had not requested to take any holiday while he was off sick, he had not actually been deprived of it, and therefore he was not due any payment for it. This was the case, even though the tribunal found that Mr. Khan didn't know he could request his holiday. It was not unreasonable that he didn't know that, and he would have requested holiday had he known. The case therefore holds that employers can deprive a worker of holiday pay for previous leave years by making a payment in lieu of unused holiday accrued in the last year of employment. Its strict interpretation of Stringer means that employees who only find out about their rights after they've left employment don't have a remedy. Whilst this is only a first instance decision of a tribunal, and in my view many other tribunals would probably have found for Mr. Khan, it's certainly a very useful decision for employers until a higher court pronounces on the topic. The next case is Nationwide and Ben, which is a TUPE case concerning the meaning of an ETO dismissal. TUPE provides that a dismissal for a reason related to the transfer is not automatically unfair, where it's for an economic, technical or organisational reason entailing changes in the workforce. The claimants in this case were managers who resigned following the transfer of the Portman Building Society to the Nationwide. The tribunal found that they had been constructively dismissed in that there was a substantial change in their job role and a substantial drop in their potential or actual earnings. It held that the dismissal was connected with the transfer, but that there was an organisational reason for the change in terms and conditions, which had a knock-on effect on their job functions. The Nationwide did not offer similar products to those offered by the Portman. It was argued on behalf of the employees that in order to be an organisational reason that falls within the ETO defence, the changes have to affect the workforce as a whole, and not just the transferring employees. However, the EAT rejected this, pointing out that the TUPE regulations themselves do not state that the organisational reason must entail changes in the entirety of the workforce. So the effect of this case is to broaden the scope of the ETO defence and therefore to make it easier for buyers or transferees to satisfy the ETO defence, which means they can avoid transfer-related dismissals being automatically unfair. The final case is Willoughby and CF Capital, which is a warning only to send a termination letter if you really mean it. There'd been discussions between Miss Willoughby and her employer as to becoming a self-employed consultant in order to avoid redundancy. And there was broad agreement as to a monthly retainer and commission, but precise terms had not been agreed. And although Miss Willoughby asked for details in writing, these were not provided. On the 22nd of December, just before the company shut down for Christmas, the company sent Miss Willoughby an agreement, assuming she'd agreed the terms, and a letter which indicated she'd agreed to become self-employed, and so terminated her employment contract with effect from the 31st of December. On the 23rd of December, the day after the letter had been sent, Miss Willoughby called the company and said she did not accept the agreement, but she did accept that she'd been dismissed. When the workplace reopened on the 5th of January, the company tried to retrieve the situation, indicating there'd been a misunderstanding, and that if she did not want to accept the terms of self-employment, then the situation could carry on as before. But Miss Willoughby rejected this and brought tribunal claims. Initially, the tribunal found that the letter should not be regarded as terminating the employment due to the misunderstanding between the parties. The tribunal said this counted as special circumstances, justifying why the letter should not be taken at face value. However, the EAT disagreed. It said the effect of an unambiguous dismissal letter is that it dismisses the employee. Employers and employees should usually be taken to mean what they say. Here, the fact that the company had made a mistake did not count as special circumstances. As to the timing, if the company had wished to retract the letter, it had to act quickly, and the intervention of the Christmas holiday period was not a valid excuse. It's obviously desirable to try and make sure that misunderstandings don't happen in the first place, but a key lesson from this case is that once you find out that you've acted on a misunderstanding, you have to act very promptly if you want to try and rectify the situation. Well, that brings me to the end of my slot. I think it's probably hard to draw any common conclusions from such a variety of decisions, but the cases do remind us that complying with employment law is a constant challenge.